Welcome to Conversations with Conti. We are trying something new. We're trying to put out some good content for our viewers. And if you like what you're seeing, please give us some feedback and leave your comments down below in the comments. Let's talk about trial, okay? Trial is expensive. It's not cheap. But the good thing about going to trial with our firm is that we're very thorough and we take it seriously and we're prepared. Depending on the case, right? Typically, if it's a full day trial, you're looking at a $10,000 initial fee. Now, if we have to do a bunch of work between mediation and trial, you will have to replenish because trial in itself, just to prepare for trial, requires us to prep witnesses, call the other witnesses to figure out what they're going to say, review all the discovery, go through our outline of proof to make sure we have all the facts we need to present our case. I mean, it's a lot of work that goes into it. It's not just we show up and we argue, right? We have to do a joint pre-trial memorandum. I guess it's a lot. Like, people don't really understand as it relates to getting ready for trial. So if it's a full day trial, you know, $10,000 to prepare for trial. A half day, $5,000. 2-day trial, $20,000. And I think we had a trial that was over a week. That's like $50,000 to prepare for that trial. And it's not that it's a lot of work. So how can you try to keep your costs down, right? Well, one, you do not want to call 50 people to say the same thing. So we have what's called an outline of proof. And we basically, for each case, we look at the different causes of actions or what we're trying to prove, and we break down all the elements, and then we add what evidence we have support that particular element, or what do we not have. And so we go through that with you before mediation with our clients, and then we really focus on that at trial because it's going to help us figure out, you know, who we need to call as witnesses. So we don't need to call 10 people to say that you're a good father or a good mother. Right? We don't need to do that. And sometimes people get caught up in, well, I want to put on my case. Well, yes, we get that, and we're going to put on your case, but we need to put on your case with information and evidence that matters.
Exactly.
Right? So sometimes people are so emotional. Like, I want to be heard. No one's heard my side, right? And we have to kind of help you realize that, yes, what you want to be heard may not be relevant to what the judge needs to actually hear.
Not everything is relevant.
Right. So not everything is relevant, although it's relevant to you and it's important to you, and we understand that, that may not, most likely will not be relevant to the case or the judge.
And you can also correlate it to the outline of proof, right?
Right.
So if you have an idea of what the court is assessing, and a party or a client wants to bring in evidence that's nowhere on the outline of proof, is nowhere going to help the court make a determination about custody or what's in the child's best interest or dividing or the particular issues for your case, then it's most likely a waste of time. So one of the things that Conti mentioned was witnesses. So you may have to have expert witnesses. You may have to have witnesses that are out of state. You may have to have witnesses that travel. There may be certain motions that have to be filed with the court in order to allow your witnesses to testify or whatever the case may be. So along with those trial costs, it varies depending upon the number of witnesses that you have that you want to use to be called, whether or not there's an expert witness or not.
And their fee to testify, in addition to their fee to prepare the report or whatever the recommendation will be.
Because what you want, the best expert witness testimony is going to have your attorney meeting with that expert witness to go over the expert witness's report, to have a really clear and crystal understanding of what that expert used to rely on their report, what objections may come up on the other side, what arguments against that report may come up on the other side. Those are all critical inquiries that have to be made before you get to trial, and you want to be able to present them in the best way, in the most efficient way possible. And so anytime that you have an expert witness, it's definitely something that's going to impact your trial costs, and also may impact the amount of time that you need to present your case. If you have experts, and if the other side has experts, you may need more than just a day of trial. And we oftentimes like to prepare our clients to say, this is the most amount of time that we think is going to, need or going to require for your case, because you don't want to, and sometimes you can't control it, but you don't want to get to trial and you don't have enough time and you have to come back, and then now it was a 1-day trial and now it's a 3-day trial and so on and so forth. So you want to be able to give the most amount of time and cut down on those witnesses, give the crucial witnesses that are going to present the case in a way that the judge can comprehend and understand. And that sometimes means making a decision to say that some witnesses aren't very good for
Not
you.
all witnesses are good.
Some witnesses don't have good memory. Some witnesses they don't articulate.
Don't present well, yeah.
Don't present well. Some witnesses, whether there's a language barrier, you have to be able to be strategic and say maybe there's another witness we can call to present this information or to get out the testimony to the court.
And to add to that, if you're looking at calling your mother or your sister, right, to say something because they're clearly biased, that's your mom or your sister, and you're looking, okay, well, is the judge going to give a lot of weight to their testimony, or will the judge give more weight to calling the principal or the school teacher, right? And so it's really, we want you to put on a case that's cost effective, that's not going to cost you a bajillion dollars, but at the same time, you have to let us help you really figure out who's important and who's not, right? The sister and the mom, okay, the judge is going to expect they're going to support their sister or their daughter, right? But a third party neutral or someone who doesn't really have a dog in the fight, the judge may give that person's testimony more weight than your mom or your sister. So it's kind of doing that balance and that analysis.
I like to think of it as like a team. So you are a part of our team. You as the client are a part of the litigation team. Without you, we can't do what we need to do. We need you to help us understand what the evidence is going to be, who the witnesses are going to be. All of the necessities of your case come directly from you at first. Then you need to trust us. That's when you need to, okay, you've given us everything we need. Now you start trusting us. You put your money in us and your trust in us, and you need to have it pay it in your favor. So trust what we're saying. If we're saying you don't need 5 witnesses that all say the same thing, and since 4 of them either don't present well or have, any other issues that make them not, if they're biased, trust us. We're not trying to lose your case. We want to win your case.
Right.
So we are not going to make a decision because we don't care. We care about your case. We care. We're invested in the outcome. So trust that if we're saying it is unnecessary, it's because it's unnecessary, or there's some other reason, but it's because we know why we're saying that. We know why maybe you do need an expert, maybe why you don't. We're there to kind of gather everything from you that you can give us, and then use our experience and knowledge to tell you what we think, how we should go, how we should present, what evidence we need to put on, And I think for me, another thing that's important is because I do have a lot of foreign clients, some of them want to try to speak English because they do speak some basic English or are able to have everyday conversations. But everyday conversations is entirely different than a court setting. A hearing or trial in a native tongue, whether you're, very fluent in it or not, is very different. And you may think that you're comfortable, but in the moment you'll realize that with the emotions, with the stress, with the judge's eyes on you, that you would feel more comfortable speaking in your native tongue, being able to express yourself comfortably. And that's something we need to know well in advance, because we need to hire the proper translators and interpreters, and that stuff is important. And sometimes you think it's not worth the cost, but in reality, I think it will never not be worth the cost.
It is absolutely
Speaking in your native tongue where you feel the most comfortable, that you can express yourself the way you truly want, is so much more important than many other expenses you can think of. So that is one that I feel is very important, regardless of how good your English can be.
In addition, you have to know that in advance, because that gets calculated into the time, because the interpreter translating for you, that time takes away from the trial time or adds to the trial time. So you need to be able to
Especially
calculate
now virtually, because
how much
before
time.
there was, in person, there used to be also some that have headphones so that it's not necessarily cutting off your time, but nowadays virtually it can really prolong a normal hearing, because they're translating every word that's being said. It's not just your words. They're interpreting all of it.
the whole thing, so you can be aware of everything that's going on.
Speaking of worth the cause, a court reporter.
Court reporter,
Do you need it?
absolutely.
Without a doubt.
Gotta have it.
It's because you may not think, it's something that if you're unhappy with the outcome of your case, you really can't do much if you don't have a record,
Mm-hmm.
right? And so, sometimes people are kind of short-sighted. I don't want to pay that. But then you're not thinking about the end game. So
Right.
if something happens in your case, you have to have a record. You don't have to get the transcript if you don't need
Mm-hmm.
it. But you need to pay the money for the court reporter, so you have that option.
I consider it like insurance.
Yes.
It's like health insurance. You pay for it, you hope you never have to use it, but you don't want to have to use it and not have it.
Exactly.
So
Yeah.
a court reporter is one of those things. It's your insurance. You need to have it because should it not go the way you want and you're unhappy, that is your only out.
Yep.
Without that, you're kind of dead in the water.
And the reality is, some judges, depending upon the judge's history and how they've handled other cases, some cases is more imperative to have a court
Mhm.
reporter than others. So, the standard is to get one,
For
right?
hearing,
For
all hearings,
all
all trials.
all evidentiary hearings, you want and need to have a court reporter there. Because sometimes that presence of the court reporter keeps people in
Mhm.
line, right? Or the other side or the opposing counsel. When there's no court reporter, sometimes weird things happen.
Yes.
I mean, people feel like, hey, free game. I can say what I want to say. But when somebody's typing down every single word that's being said, they're less likely to say the craziness.
Right.
Just think of it that way.
Mm-hmm.
Right. Another, it depends. People always want to know how long does it take to get to trial. It depends on your judge. It depends on their docket. It depends on, some judges you can get in. If you file notice for trial, you might have a trial date or a case management conference within a month or two. Some judges, it could be 8 months. It really depends. But the attorney should be familiar with the judge and kind of tell you what they think, how long it will take based on how they usually act. But it really depends on your judge.
It really does, and it depends on how much time you want for trial.
Right.
If you only need a half a day, then you may be able to get in before somebody who needs 2 or 3 days.
Right.
Mm-hmm. Mm-hmm.
So it really just depends.
Now, because it does depend and the time frame varies, you have to be ready to go to
At any
trial
time.
when you make that decision to say mediation hasn't worked and we want to proceed and we want to go ahead and move forward with the case, because there's a difference between getting ready and being ready to go to trial within a month as opposed to being ready to go to trial in 6 months or whatever the case may be. Sometimes you don't know. So that's the reason that you have to be ready. Once we file that notice to the court, letting the court know that your case hasn't been resolved in mediation, you have to be ready to go with your witnesses, with your evidence, with your trial retainer costs, right?
And financially, you need to be ready
right.
to go to
Mhm.
trial.
Right.
Mm-hmm.
Financially, you have to be ready to go to trial because it's you have to pay up front the initial trial fee, which is $10,000 for a full day. So you need to make sure you're financially ready, in addition to having all your other ducks in a row as it relates to
And all the costs that are third party.
third party costs too. So
All you have to pay outside of the retainer.
Right.
It's always nice to think that all comes into that same batch, but it doesn't.
Mhm.
There's the retainer that comes for us and what we have to do, and then all the experts that you may need along the way.
absolutely.
And you also want to think about records. So sometimes before we get to trial, we send out subpoenas. Sometimes we take depositions. Those are additional costs that you have to consider. Do you want to depose this person before we get to trial? Is it necessary? Do you want to send out subpoenas to third parties? Are there going to be costs associated with those third party subpoenas? Because oftentimes when you request records from a third party, that third party may require you to pay a certain cost in order to get the records. Right, so you want to factor that cost in. You want to factor that time in. All those things are going to have an overall impact of how your trial is going to unfold. And sometimes there's a judge that's going to get you set really quickly on the docket, on the trial docket, and there's sometimes where there's going to be a little bit of a wait. And then you also have things that are outside your control because sometimes divisions change, judges switch. Sometimes judges are out.
Sometimes we have a pandemic and things shut down. I mean,
Right.
we really have no
Seriously.
idea how things play
Seriously.
out. So there's many things that can get in the way, that can interfere, that are well beyond any of our control.
And back to patience being key. Like sometimes we're just like, I just want this to be over. And trust me, we want it to be over too. Because the sooner we get you through the process, the better you feel about the job that we did for you. Like, we took the case, and if it kind of just goes on and on, you start to feel like, well, why isn't this getting resolved? I came to a lawyer, I thought this would go faster. And chances are it's probably moving faster with the lawyer than it would have been if you didn't have the lawyer. So there still has to be that element of patience that you have to have when you're looking to move through to trial. And so when we talk about things like depositions come at a cost. We have a court reporter, again, that's there typing away everything everybody's saying. And if they say something in that deposition that we feel is key, we're like, hey, we need to get this deposition transcribed. So you know what? That's another cost. And that's a cost that you bear that does not come out of the trial retainer. Because the trial retainer, remember, that fee is for lawyer fees. You have to pay these additional costs separately. So when we talk about taking advantage of mediation and seeing what you can resolve, this is when these numbers really start to matter. Because going to trial, the road to trial is paved with depositions and subpoenas and third-party requests for production, all these things.
Costs that add up.
That add up. And you're like, hey, wait a minute, why I got paid? You know what? You want to go to trial. This is the road to trial.
But if now, depending upon the advice of your lawyer, because sometimes your lawyer may have advised you to settle in mediation to avoid all of those things, right? That may be one of the motivating factors, so that you can see, if you don't settle, here's the additional work that we have to do. Here are the additional expenses that you can anticipate if we don't settle, right? Not saying that you have to settle, but if you make the decision to not settle, here's the numbers.
Comes at a cost.
And that's the thing. So when we start talking about settlement, we go into mediation. We have equitable distribution charts and everything. So we're looking at all your assets. And so if you're sitting in mediation, you're like, I don't want to give him any of my 401k. Okay, well, this 401k, whole thing gained during the marriage. So guess what? It's subject to equitable distribution. But you only got like $100,000 in there. But you don't want to listen to us and go ahead and say, okay, well, it's subject to equitable distribution, so yeah, he getting half or she's getting half, and then
you spend that much.
You spend that, like, because you've already spent the initial fee for this divorce. You've spent part of that, and then we're setting up for one whole day of trial, so that's another 10 G's. So I mean, you've spent a third of that. At some point, a third of what you would have kept.
You have to ask yourself, is it worth it in my case to go to trial, right? Because, and we'll tell you,
we don't sugarcoat it.
We'll be very honest with you. So sometimes if you don't listen to that advice and you continue and you proceed to go to trial, and sometimes you may end up with a result that you're not happy with because you made a decision to not settle that mediation or listen to the advice of your counsel during the mediation and try to resolve the case. So when we can tell and we know, like, a particular judge or just what the law is, how the law is applied, we'll let you know your better chances are to resolve. And if that's the case that we're telling you that, you want to do that well in advance, and don't do it at the last minute if you can avoid it, because you're going to incur those costs. Now, if you're in a situation where you say, well, yes, I want to resolve it, but we're still going to trial, we have to do both. Right? If we're gonna work towards settlement, but then also prepare for trial,
you're paying for both.
You're paying for both.
Even if you settle the day before, you're paying for both. So it doesn't change the work leading up to it, So because we can't wait until the last minute and say, oh, okay, well, now that it didn't settle, we'll prepare now. You don't want us to do that.
It doesn't work that way. So when you're looking at a day trial, so we're talking 7-8 hours, okay? That's 7-8 hours right there of attorney time actually in court. But for every attorney hour in court, there is 2 to 3 hours of prep time for that 1 hour, because you have to manage information and evidence. So you have to prepare to present that evidence in the most concise and efficient way possible in order to get everything persuasive in this amount of time. Because remember, even if it's set for a day, half that time is allocated for the other party, okay? So we have to put on a full case within a certain amount of time. And so that requires substantial preparation to present it in a concise, persuasive way.
here's what I would say as well, based off of what you just talked about with the limited amount of time, is that your attorney may tell you we only have a certain amount of time to present our case. Not every issue or every argument or correspondence is going to be talked about at trial. It's not worth it. We don't have time. We have to move on, because we have to be able to use our time in areas where it's going to matter, where it's going to get you the result that you want. And so you have to trust that your attorney says, well, we don't have time to really talk about the dispute about the socks and who left them at the house and who didn't bring the socks and who left the backpack. We don't really have time to talk about that, but we do have time to talk about some of these more pressing issues, about work schedules and how much time the spouse, more important.
Relying on third parties to take care for the kids.
Right. There are other areas that I can fight for your case, and it has more impact with the judge than arguing about socks.
And that's the thing. Like, sometimes we get caught up in the weeds, and I may call them weeds, but they're big things to you.
Right.
But I'm like, at the end of the day, that thing doesn't matter unless it impacts the finances. So I'm not going to focus on the infidelity unless it dissipated some marital assets. If they was just out here cheating and having a good time, but they ain't cost you a lot of money, honey, let's not worry about that. Okay? Let's focus on the fact that there's some money to be divvied up. There's assets to be divvied up. Let's figure out when we gained control of those assets. Was it premarital? Was it during the marriage? Let's figure that part out, and focus on what's in your control now, because we can't control behavior that happened prior to. So just think about, a lot of things have happened, but let's pinpoint the things that impact children and assets and liabilities. That's it. And it's hard when you're in it
And when you're in
to see it clear.
Right.
So we're here
to help you make that
to
distinction.
give you that clarity and say, hey, that is valid. Your hurt is valid. Your disappointment, your anger, all of that is valid. But my job here today is to get you out of that circle and into, let's see what you're entitled to. Let's make sure you get it.
And the things that are going to matter to the judge, right? The things that are on that outline of proof, the things that are part of the statutory factors, the things that we know the court is considering according to what the law is. We will redirect you to highlight those issues, because we know that that's what the court is looking for. That's what the court wants to see. They don't want to see the argument in the text messages about the socks and him being 5 minutes late to the exchange. There's a priority of things, and we're here to help you navigate what's at the top of that priority list and what's at the bottom, and where should you put your resources, and where should you put your time and energy, and where we're going to put our time to focus on to help you get the best possible outcome.
I think an important aspect of trial prep is witness prepping, and people don't understand how time-consuming that can be.
Right.
Not everybody is prepared to speak on even a topic they know very well immediately. A lot of people need a lot more time to understand how to answer, what you should or shouldn't answer. And that's also a way to kind of weed out certain witnesses sometimes, is you're realizing this person's not going to present well, this person's not going to answer the questions the way we need them to. They're just, we can't reel them in.
Right.
And then we can kind of weed some people out. But we have to go through that step.
Right.
We won't know that without it.
And that's the thing, like we say, submit to us a list of people that's going to testify on your behalf. Also, tell us what they're going to testify to.
Exactly.
What important thing about your case are they going to testify to? And if we look through your list of witnesses and they all want to talk about you being a good parent, or,
we're gonna make
we don't need all those people, okay? I would rather the child's teacher say that you're a good parent, you're involved, you're in PTA, you're attending the meetings or what have you, or you're dropping the child off on time, all of that good stuff. But I don't need your two best friends saying, oh, she's like the best mom, or he's like the best dad. We don't need all of that.
That's not
because
helpful.
we don't need character witnesses in this situation. Now, if somebody is saying that you've been abusive towards the children and you've done certain things, we may need some witnesses to come in and say, I've only seen this person be loving towards this child, and testify to that. But we don't need a bunch of people saying, no, she's a lovely person. I don't even understand why they're getting a divorce.
Especially if we're only dealing with things that have nothing to do with that.
Right.
So like, we're dealing with money. And you're like, come in and say how great I am as a parent.
We're trying to get you some alimony.
What does that have to do? Yeah.
What does that got to do with you being nice?
So also meet with your witnesses or have a discussion with them about what they know and what they remember before you send me to talk to them. Right?
Because what you thought that they knew is not always what they actually know.
Right.
And now we have spent maybe 0.3 billable hours on listening to them talk about, and you're like, okay, but what? Oh, okay, yeah, no, we're not using them. So vet your witnesses better.
Right.
And so when we tell you, okay, well, these are the issues of your case. This is what we need to prove. Who can speak to those things?
Who has personal knowledge of those things? How do they know? So, we want useful witnesses. We can't use somebody who knows that, the other parent was late because they talked to your sister, friend's best friend's cousin, and they heard it through the grapevine. That's not a person. That's not a valuable witness to us. We need people who saw things personally, observed things personally, heard and saw things themselves, have personal knowledge. Because if not, you're wasting our time and your time to talk to people.
You're wasting your money.
Yeah.
You got to stay focused. Stay focused on the end game. Stay focused on what your desired results are and how do we get there. And as much as it's an emotional thing and you want to get out all your story, this is not storytelling time. This is not, show and tell. We're not here to tell whatever you want. We're here to get a desired end goal. So how do we get there? How do we best accomplish that for you in the most efficient and effective way possible? And as much as you want to get into all of that other stuff, you have to be able to let that go and just focus on what matters. It's like be a horse with the blinders. Like you have to stay focused on the end goal. So you're not wasting money on things like presenting us witnesses that aren't going to provide anything useful, or presenting a bunch of text messages that in the end aren't going to help with anything.
Right.
So it's important to be able to understand also that not everything you're going to provide to us we can present as evidence. There are things that we won't be able to get in for one reason or another. It's also understand that there are legal rules and statutes that we're bound by that keep us from being able to present everything you want us to, and understand that if we're telling you we physically simply cannot present that, it's not going to happen, it's either irrelevant or it's hearsay or whatever the reason, we have a reason for explaining that. We're not just saying no to say no. And you have to understand that some things are outside of all of our controls. There are rules we have to follow, and you have to follow them as well. It's a part of your case.
Right.
I would also say if you have any particular parts or portion of your case that you're concerned about, if you are, have personal things that you're working through or have issues, talk to your attorney about those things before you attend a hearing. For some people, they may have fear of speaking in front of a judge or public speaking, or they may have, certain issues with being able to articulate, or they may have a disability, or they may have certain problems with speech. So you want to be able to address some of those things before you attend a hearing, when you have the opportunity to practice, so that you can work them out, so you can figure out how to overcome some of these obstacles, and it's not in the moment trying to navigate it when you're in the middle of a hearing or a trial, but you would have discussed different options and different solutions to address the issue, not at the last minute or in the moment of.
Now, with that, sometimes in the course of your case, something may come up that wasn't there at the beginning, and we may need to amend your pleadings. Let's just say you all of a sudden have a substantial diagnosis, so maybe you get diagnosed with cancer, and this changes your ability to earn income, or you have a situation that comes up that's really going to impair you in some way that changes how we need to approach your case. We may need to amend your pleadings, and those are things you need to tell us. Like if something big comes up and you just feel like, I just want to keep this to myself because I don't want them to know, because I'll feel like the other party's going to take advantage of the fact that I'm sick and maybe try to take the kids from me, or whatever the case may be. If it's something big, we need to know.
If you're pregnant during a divorce,
we need to know. We need to know.
Don't keep that from anyone.
Oh,
you're like, I'm not gonna be showing. How long away is trial?
Man, we need to know.
I'm not gonna be showing. Okay, it's a reason that in the petition, we say that neither party's pregnant
or expected.
Very-
So
And
what
don't
are some-
think that if it's not his, that's why you thought it wasn't important to tell
Right,
us.
it's
That's
we need to
actually
know.
more of a reason to
To know.
tell us.
So
You
what are
have
some
to.
things we just need to know? I have one. If your your live-in boyfriend, if he has a federal criminal history that involves kids or something, I need to know that. We need to know.
Any kind of criminal history, really.
Any
at
kind
that
of
point.
criminal history, because I'm telling you, they're gonna
coming
throw everything out there. If there's some children involved,
Mm-hmm.
and you have an offender living in your house, and it doesn't matter to the other person what the crime is,
Right.
they hear that person got criminal history.
We need to know.
We need to
yeah.
know what it is, because we don't want to find out from the other side. We need to find out from you.
DCF investigations.
Mm-hmm.
We need
really
to know.
We need to know.
We need
Yeah.
to know.
We need to know if, in fact, you were not living with anyone. It's just you and the kids, and you thinking you're gonna move somebody in there. We need to know.
If you've ever been convicted of a crime involving dishonesty,
We
need to know.
Yeah.
If you've ever had an injunction entered against you, filed against you,
Any other pending cases that
Yeah.
are happening at the time?
We need-
Bankruptcies. We need
We
to
need to know.
During a divorce, if you are going to file for bankruptcy, please talk to your attorney beforehand.
Before,
That is
not your bankruptcy attorney.
vital.
Us.
Yes,
We need to
we
know.
need to know beforehand. A bankruptcy changes the dynamics of a divorce case. Similarly to a pregnancy changes the dynamics. We need to know all of these things as they're happening. We understand that things change.
Right. If you plan on moving or relocating
Oh my, yes.
anywhere, 50 miles or less or more than 50, we need to know.
Yes, yes.
Okay?
Yes.
That's
yes.
important.
Yeah.
If you're contemplating making changes to insurance policies, health insurance, if you want to do that, and before you
Yeah,
do
please
anything,
don't do anything. Without talking
We
to us.
need to know. If you are planning, like, say you're paying for the mortgage or something, you want to stop paying,
You plan on stopping?
we need to
Yeah,
know
we need to
because
know.
they can file a motion for contempt or and that's a whole nother thing. Like, we need to know anything that's going on that can impact your case whatsoever. We need to know so that we can properly advise you and so you can avoid any major pitfalls that may happen as a result of your
If your
ignorance.
children start having issues at school,
Yes.
if they start having behavioral problems, I mean, this happens very frequently during divorces, especially heavy litigated cases. The children are impacted, whether you think they are or not. And if they start having behavioral issues, or if you start to realize whatever your arrangement is that you're actively doing is not working, we need to know that. Otherwise, we're going to think you're comfortable in this current arrangement, and that's what we'd be pushing for. So we need to know all of these little changes that happen in the middle that maybe you didn't even realize were happening. But anything with your kids is important to tell us. Anything that's happening with your children during the case.
I mean, and sometimes you have instances where you have blended families. So there are other children in the home that may be there when your kid is there or not there. If there are circumstances that are important for that other child that's in the, let's say for instance, if that child has a juvenile record or a criminal history or something of that nature and is going to be spending time with your kids, those are things that we need to know, right?
Yeah. So we need to know a lot.
We need to know it
Everything.
all. We
Make
need
sure
to know it all.
Everything.
Tell us everything.
Tell us everything, and so that we can properly advise you. So.
Thank you for tuning in to Conversations with Conti. If you enjoyed our commentary, please leave your feedback below. And if you have any topics you want us to cover, please leave that in the comment section as well. Make sure you subscribe to our YouTube channel and follow us on Instagram and Facebook at Conti More Law.